Hey everybody, how's it going? It's the Daily Shooter, and before you get mad at me and start typing away because of the title of this video, that's what the Ninth Circuit Court of Appeals en banc panel said on March 14th of 2021. Quote, "There is no right to carry arms openly in public, nor is any such right within the scope of the Second Amendment." Absolutely ridiculous. That is why the Ninth Circuit is the most overturned court in this entire country. Well, guess what? The Supreme Court has decided to hear a case that just might overturn that. So let's go ahead and talk about it. This channel is proud to be supported by the USCCA. The U.S. Concealed Carry Association helps responsible Americans like you prepare for what happens before, during, and after an act of lawful self-defense. USCCA members get life-saving education, expert training, plus defense liability insurance. These benefits provide more than 500,000 USCCA members with the peace of mind that they deserve. Plus, a USCCA membership is always risk-free with their 100% money-back, bulletproof guarantee. Membership is truly an investment worth exploring. Click the most important link you might click ever down below and activate your U.S. Concealed Carry Association membership now. So anybody with more than 2 brain cells can see that the Ninth Circuit Court of Appeals made an activist decision at that point. They did not use the Second Amendment as a basis for anything. They try and say that they do, but nowhere in the Second Amendment does it say that there are limits on where the Second Amendment applies. It says that the right of the people to keep and bear arms shall not be infringed. It does not say anything about as long as it's within their home or as long as it's within their business. The right of the people to keep and bear arms is absolute, and that right remains while you are in this country and under its laws. The Ninth Circuit Court of Appeals just decided to add that stuff and kind of reference the Second Amendment as why they could. But again, it's another clear sign that the Ninth Circuit Court of Appeals is an activist court and not a court that is in any way legitimate within the law. They try and impose, again, their own will, their own thoughts, and their own wants on the citizens that are under their jurisdiction. Now, the case that I'm referring to with the Ninth Circuit Court of Appeals is Young v. Hawaii. You can always look up Young v. Hawaii, Ninth Circuit Court of Appeals decision, and you could read it for yourself, and you can see the quotes that I'm talking about in there. It's so insane that it sounds like I'm making this stuff up, but it's not. It's real. That is actually a quote from a judge on the circuit court. So the case that we're going to be talking about when it comes to the Supreme Court that could actually overturn that is the New York State Rifle and Pistol Association versus Corlett, which actually challenges the good cause requirement. Now, there's been good cause challenges all over the country. California good cause challenges, we have New York, we have New Jersey, we have Hawaii. All have gone through the court system, but none of them have made it to the Supreme Court. So that's why this one is extremely important. Because of the good cause requirement, if the court deems that there is the good cause requirement is unconstitutional and there shouldn't be a requirement in order to get a permit, or that maybe even permits are unconstitutional, this would overturn the ruling by the Ninth Circuit Court of Appeals in Young v. Hawaii, meaning that all of these states right now that have these massive restrictions on how to get a permit and, you know, the process that you have to go through and the legal requirements that you need in order to get that permit could be completely overturned, meaning that everybody in all 50 states can carry, open or concealed, if we get the right ruling. Now, what really surprises me here is that the Supreme Court has taken up a Second Amendment case at all. I made a video about this not too long ago talking about how the Supreme Court has failed the Second Amendment. They refused to take cases. There was a huge swath, like 8 to 10 cases, up for a decision on whether or not the Supreme Court would hear them, and the Supreme Court kicked every single one of them back to the lower court. So they didn't hear a single one of those cases, and they were all very important cases. So I didn't have much faith in the Supreme Court hearing anything. So this is kind of a big surprise. Now, try and keep in mind that while this could be great for the country should we get a favorable ruling, it could also be very detrimental to our Second Amendment rights as well, because again, when the Supreme Court makes a decision, it affects the entire country. So while there is an upside, there is also a potential for a downside. And if they say that the good cause requirement is constitutional, then we could see that be implemented in more states. Now, there is a reason why some states are implementing constitutional carry. Those are the states that have realized that the Constitution does not have limitations on where you can access your rights. If you read the Second Amendment again, it's a very easy read, it's very short. If you read it, it does not have any limitations on where. There is not any specified where you can practice this. Just like with speech, it doesn't say that you have free speech while you're in your home, while you're in your business or your dwelling. It just says you have free speech. The Second Amendment is exactly the same way. So if you're going to treat the Second Amendment and the First Amendment differently, then we need to have a much bigger talk. So again, some states realize that the Second Amendment is absolute throughout the entire country, and that is not limited to any particular space, and that's why they're implementing constitutional carry. The fact that we even need a permit to carry, in my mind, is unconstitutional on its face. So there shouldn't even be a permitting process. If you need a permit to access a right, it's no longer a right. It's a privilege. And you can't take a right like the Second Amendment and turn it into a privilege. It's just, I could start really going off about this. It is one thing that really gets under my skin, the whole rights versus privilege thing, because it seems like the people who are in charge of making laws have completely forgotten the difference between the two. Nonetheless, it's exciting to see that the Supreme Court has taken up a Second Amendment case. Let's hope that they look it over and they give us a favorable decision in the end. This stuff takes a lot of time, so obviously when anything else happens, I'll give you guys an update. Thank you all very much for watching. I really do appreciate it. Please like, subscribe. Have a great day.